Start. Learned counsel for the victim has read out the entire order from internal page 3 onwards regarding the findings recorded by the learned trial court for rejecting the discharge application. It has been pointed out that no foreign material can be considered at the stage of moving discharge application before framing the charge. Sections 193, 207, 209, 226, 227, 228 of the IPC have been pointed out, and also section 216 of the CRPC to say that sessions trial is different from the trial held by the magistrate. It has been pointed out that in sessions trial, the charge sheet is filed before the magistrate. The magistrate, after taking cognizance on the charge sheet, issues summons to the accused on the basis of documentary evidence filed along with the charge sheet. Thereafter, he commits the case for trial before the sessions court. The revisionist has neither challenged the cognizance order nor the order passed by the magistrate committing the case for trial to the sessions court. The charge sheet had also not been challenged by the revisionist number 1. The charge sheet was challenged by his son. The challenge was rejected by this court. It has been pointed out that the power under section 22A has not been exercised by the sessions court only if an order passed under section 228 within bracket 1 within bracket A is passed. Can the accused have any ground to come before this court saying that his right to appeal has been taken away? The order that has been passed by the sessions court is with regard to the discharge application of the revisionist, and the jurisdiction of this court is limited over such an order under section 397 CRPC. Learned counsel for the victim has relied upon the judgment rendered by the Honorable Supreme Court in the case of Sanghi Brothers Indore Private Limited versus Sanjay Chaudhary and others, AIR 2009, Supreme Court 9, paragraph 7 and 8, as also judgments that have been cited by the learned trial court in the order impugned. The learned counsel for the victim has also pointed out that the judgment rendered in the case of Sanjay Kumar Rai versus State of Uttar Pradesh and another in criminal appeal number 472 of 2021 decided on 7/5/2021 and paragraph 11 onwards the same. Learned counsel for the victim has also pointed out that the statement of Sri Rajkumar Singh at page number 33 saying that he has not disputed the meeting of the revisionist and his son with the then consolidation commissioner in his office, and he has also not disputed the presence of other peons like Ram Kishan, Chandan Singh and others. There is no dispute regarding the medical conducted of the victim where injuries has been shown on the face, on the head and on the neck of the victim. It was only because the peons working in the office of the consolidation commissioner who came nothing to his office that the attempt at strangulation of the victim was threatened. He has pointed out from the statement of the opposite party number 2 and his affidavit that Rajkumar Singh has not said anywhere that he had not given any statement under section 161 of the CRPC to the police. The incident took place on 13/7/2016. The counter affidavit that was filed in this case was also the affidavit that was filed before the learned trial court by Rajkumar Singh is dated 28 August 2018, that is 2 years after the incident where Rajkumar Singh has turned around and suddenly stated that he was forced into lodging the FIR because the influence of the then consolidation commissioner in whose office he was working as a peon. This court must first consider the scope of interference under section 397 of the Criminal Procedure Code. The Supreme Court was considering the scope of powers granted under Section 397 and 482 of CRPC to the High Court. In paragraph 2 of its judgment, the Supreme Court framed the question of the law. Thus, a question of law that arises more often than not in criminal cases is that the extent and scope of the powers exercisable by the High Court under Section 397 independently or read with Section 482 of the Code of Criminal Procedure